Good morning to you. In the last class, we have seen under Constitution the provisions of national emergency and its effect. That is Article 352. We have seen. To recapitulate what we have discussed in the last class, number one, during national emergency, the executive power of the Union will extend to giving directions to any state regarding the manner in which the executive power of the state is to be exercised. What does it mean? It means that the state governments are brought under the complete control of the central government. This is number one. Number two, the parliament can make law on any subject in the state list. That is, the normal distribution of the legislative powers between the center and states is suspended, even though the state legislatures are not suspended. State legislatures are not suspended, but the normal distribution of powers in Schedule 7 stand suspended. In other words, the state subject will become concurrent subjects. Both the state legislatures and union parliament are competent to make law on the state subjects, but subject to overriding powers of parliament. This is regarding the legislative powers. Secondly, during national emergency, President can issue ordinances on state subjects. Obviously, because there is no state legislature and it is under President rule, so naturally President is competent to issue ordinances on state subjects. The distribution of revenue between union and the state can be modified. That is, the financial relations between the union and the state are modified. Every such order of the President, of course, should be placed before both the houses of parliament. This is the safeguard. Then we have also seen that the life of Lok Sabha can be extended beyond its normal term of 5 years by a law to be made by parliament for 1 year at a time. 1 year at a time. Nevertheless, this extension of 1 year cannot continue beyond 6 months after the expiry of emergency. Any number of years you can extend by a law to be made by the parliament. Based on the law, President will make a proclamation. For example, the term of 5th Lok Sabha from 1971 to 1977 was extended for 2 times by 1 year at a time during Mrs. Indira Gandhi's time. Similarly, Parliament can extend the normal tenure of state legislatures, state legislative assemblies in precise, by 1 year at a time during the national emergency, subject to a maximum period of 6 months after the expiry of emergency. So remember, number one, parliament powers. Parliament, that is Lok Sabha tenure is extended by a law to be made by the parliament 1 year at a time. Every year a law has to be made and it can be extended. The similar provision exists for state assemblies also. Now, the right to move Supreme Court. The right to move Supreme Court under Article 32, that is the right to constitutional remedy, can be suspended under Article 359 by President. Kindly note, the fundamental rights as such are not suspended. Fundamental rights as such are not suspended, but only their enforcement is suspended. This means that the suspension of enforcement relates to only those fundamental rights which are mentioned in the presidential order. Nevertheless, most importantly, the enforcement of Article 20 and 21 cannot be suspended. That means the enforcement right, Article 32, can be suspended in respect of all other rights, but not for Article 20 and 21. Most important. Then comes Article 19. Article 19 stands automatically suspended if the emergency was declared on the ground of war or external aggression. These are the two grounds. To put it positively, Article 19 cannot be suspended if the ground of national emergency is armed rebellion. So that provision is not there. Now we are coming to what is popularly known as President's Rule or constitutional emergency or state emergency under Article 356. Very important academically and also from examination point of view. What does it say? And the President Rule or constitutional emergency or state emergency, all the three identify the same. You know, there is an Article 355 which enjoins upon the Union to protect every state from external aggression and internal disturbances. That is, Article 355 enjoins upon the Union to ensure that the government of each state is carried on in accordance with the provisions of the Constitution. This is the power which has been given to the Union to keep a watch and act to ensure functioning of constitutional machineries as per the Constitution. The Union government is, remember, duty bound to take over the government of the state in case of failure of constitutional machinery in the state. So, you have to read the Article 356 only in the light of Article 355. So, now read Article 356. If the President of India is satisfied on the basis of the report of the Governor or otherwise, remember, report of the Governor or otherwise, that a situation is arisen in which the government of the state has not been carried on in accordance with the provisions of the Constitution, then the President can declare President's Rule. So remember, on the basis of the report of the Governor or otherwise, that means without the report of the Governor, also the President Rule can be imposed. For example, in 1991, Karunanidhi government in Tamil Nadu was dismissed, though the Governor of Tamil Nadu at that time did not recommend President's Rule. So, on the basis of the report of the Governor or otherwise, if the President of India is satisfied that a situation has arisen in which the administration of the state has not been carried on in accordance with the provisions of the Constitution, then the President Rule can be imposed. Every such proclamation, other than the one which is invoking, is valid for 2 months. So, what is the time limit for President rule? 2 months. Within this period of 2 months, the proclamation has to be approved by both the houses of parliament by simple majority. Remember, only simple majority. If Lok Sabha is dissolved during this period of 2 months, Rajya Sabha will approve it first and Lok Sabha will approve within 30 days from the date of reassembly after general elections. Remember. Now, once a proclamation is approved by both the houses, that proclamation is valid only for 6 months from the date of issue. From the date of issue, kindly don't calculate after the approval, not after the 2 months. So, not 2 months plus 6 months. It is only 6 months from the date of issue. This may be extended for 6 more months in continuation if both the houses approve the extension before the expiry of 6 months following similar procedure as for the first approval. So, 6 months first proposal, second another 6 months, 6 months period is over. During this second 6 months period, if Lok Sabha is dissolved, Rajya Sabha will approve it first and Lok Sabha will approve within 30 days from the date of reassembly. So, 6 months and 6 months. Nevertheless, the President rule cannot go beyond 1 year unless 2 conditions are satisfied. What are the 2 conditions? Number 1, President rule can be extended by 6 months after stipulated period of 1 year subject to 2 conditions. Number 1, national emergency should be in operation either whole of India or part of India. Number 1 condition. Second condition, the election commission should certify that during the period specified in the resolution, it is not conducive to hold elections in the state. Remember, the election commission acquired prominence, importance only through this article. Remember, in this process, by giving 6 monthly extension, the total period of President rule should not exceed 3 years. So, in other words, normal 1 year, that is 2 6 monthly extension plus 4 additional 6 monthly period extension subject to the condition of national emergency and certification of election commission. If the President rule is to be extended beyond 3 years, the constitution should have to be amended. Otherwise, you cannot continue the President rule in any state beyond 3 years. Nevertheless, if the ground for imposing President rule is different, then there is no need for amendment of the constitution. What does it mean? Suppose, let us say, the President rule is in operation, you hold election, in the election there is a fractured verdict and it is not possible to install a ministry, yes, it is gone. Alternatively, there is a state under President rule, President rule lifted, election conducted, and election conducted. In the election also, the fractured verdict or the Council of Ministers are defeated on the floor of the House, then you have to impose the President rule. So, if the ground is different, then you can impose President rule without amending the Constitution. Alternatively, otherwise, remember, most important thing, beyond 3 years, you cannot continue the President rule in any state unless, number 1, Constitution is amended. Alternatively, The ground for imposing president rule is different. This is the president rule. What are the consequences of president rule? We will see tomorrow. Thank you.